Welcome to AARP, Arizona Hispanic Connection. Educate. Celebrate. Connect. Arizona Hispanic Connection.
Hello, this is David Parra, and welcome to AARP Arizona Hispanic Connection with another very, very important show, important subject. Today we are addressing living trust, transfer of wealth. So living trust, a lot of times people are more familiar with testaments, right? They're more familiar with wills. But there is another legal process, if you will, that many people might not be as familiar, and we wanted to do this show to inform the community about the different processes, legal processes that there are available, and how each functions, so that people make their choices. You know, some people may feel comfortable with just doing a will or a testament, but there's also this concept of living trust. And so we wanted to address this matter because let me read some introductory lines that I have on here on my computer. Wealth, right, is first built. You build your wealth, you create it, then it is preserved. Then, you make it grow. You have maybe you went to college, maybe you develop a profession, you started making your money, you're creating wealth, and then you have to kind of make it grow through investments and this and the other. Then one day it will need to be transferred. This is very, very, I guess, rudimentary, very, very basic. Not one of these steps, meaning building, preserving, and transferring wealth, is easy. But the last one, in many instances, in other words, the transfer of wealth tends to generate the most problems, especially family problems. In most cases, for lack of planning. So creation, again, you get a job, you get a profession, have a business, then the growth element comes in, you invest, retirement plans, Social Security, savings, business, products, services, real estate, etc., life insurance. And then comes the transfer of wealth. And some do nothing, and that goes to probate, right? And some just do a testament or will. That will also go through probate. Then there is living trust, which is part of the estate planning, lack of planning, right? In transferring this wealth causes many problems and lots of money. So in short, we would like to share with you, our listeners and followers on Facebook, what are you going to do to transfer whatever wealth you accumulated during your lifetime? And I really believe this is a very, very important subject. Let me introduce our guest, and I'm just going to start from my left, going this way. We have Allison Snow. She is an attorney at law with the Endowment Law Group.
Hello.
And you are an attorney at law. Thank you very much, Allison, for joining us.
Thank you for having me.
Yes. And we'll be covering some of the aspects that I just mentioned, but from the angle of older adults, correct?
Correct.
Perfect. Lupe Solis, she's with us. And Lupe Solis, it's a community advocate, and I know because of our friendship that you are kind of going through that, and we really wanted to get your perspective. I also wanted you to be with us because you also, I believe, have the community, a knowledge of the community of what families go through when they plan it, when they don't plan it. And I'm also going to kind of join you in that areas. But first of all, Lupe, thank you so very much for making time to be with us. Welcome.
Thank you, and thank you for treating this very important subject.
And that's what I was going to ask you just off the bat. Do you believe this is an important subject?
Very important for families to understand how needed planning is.
Right. And again, the issue is, how are you going to transfer your money? How are you going to transfer your accounts? How are you going to transfer your assets? Right. Now, we also have Alejandro Perez, and Alejandro Perez is also an attorney at law, and you work for your own company, I understand, right? Alejandro,
I do.
The firm of Alejandro Perez?
The law firm of Alejandro Perez.
Law firm,
yes.
yeah. Thank you for being with us, Alejandro, for always being willing to be with us. And
Well, thank you for having me.
So let me ask you, first of all, let's talk about, before we go into the Living Trust, hopefully we can just use the remainder of this segment. How tough is it to make the money these days? And basically, let me just leave it at that, because you and I, Allison, were talking off the air, and a lot of times we think about this state things, and I mean, are there people out there that really have things and they need to take care of them, or it really doesn't matter how the amount of assets? It's always good to plan and do this kind of processes.
Right. I think, and Alejandro can speak to this as well, but I think one of the misconceptions about estate planning is that it is only for the wealthy, and it is expensive. And we have really seen in the legal community that the cost of estate planning has fallen. It is far more competitive. And there are other concerns, as you and I talked about off the air, just besides wealth, care for minor children and what happens in the event of your death or incapacity. And we can certainly speak more about individual situations, and I'll let Alejandro speak to that.
I like that concept. So it is true. I mean, if I don't have a lot, I don't kind of see the need for the Lupe. What would you say about that? Do you know that's prevalent in the community?
Definitely very prevalent, especially in our Hispanic community and in the minority communities. And one of the things that I would remind people is that one wealth transfer that happens in families is the transfer of property, real estate property.
Okay.
Oftentimes, you will have a family that's living in a house that's owned by grandmas, let's say, but there's others living there who need that house in order to make it. Today's salaries don't often provide for all the needs of a family. If you fail to plan, it is likely that property will fall into probate. Not only does it take time, it becomes costly, taxes accumulate, and oftentimes what I've seen is families end up losing that property. So
and then becoming almost enemies because of family problems.
Well, family problems, but also then their economic situation exacerbates, because now you're faced with not only you don't have a place to live, you're having to pay expenses that you never thought you would have to pay. So it's very, very important that you realize this isn't only for the wealthy. This is a way to preserve what you've got.
And I have a family of 8. I come from a family, of 9, and my wife, a family of 11. And there are several 50-plus people already in our family, and I can almost guarantee, I know them pretty well, that none, including myself, have made those arrangements. Before we go on our first break, Alejandro, your impression about the Hispanic community and going through this kind of processes to basically deal with the wealth, assets, whatever they are, a house, plans on 401ks, bank accounts, cars, whatever it is. What is your impression?
Well, first of all, whatever you have, however much or however little you have, it's yours, and you deserve a right to say what's going to happen to it, and you deserve a right to protect it legally. Frankly, a will is a deficient way to leave your property. You should be looking at a estate, or go see an attorney about some other methods of passing things along that don't require going through probate or the laws of intestacy, which we may get into, which happens if you don't have a will. But the Hispanic community, in my impression, has done a very poor job of preparing. It's not part of our culture, succession planning and preparing for our future. We think that our children or our brothers and sisters will take care of us, when that's not the case. And we also obviously do not want people making decisions that they're uninformed. They don't know whether or not we'd want that, and leave them wondering, I wonder if I did the right thing. So an estate plan is a perfect way. It's like insurance in many ways, and it makes sure that your will is heard and whatever you want to happen it occurs.
I am aware of family members, families who became literally divided over these issues and sometimes it's not even a lot.
Oh,
it may be an adobe house. Come on, it may be just something so insignificant in terms of not the value, but the price.
Coming from a psychological point, I think many times the least you have, the more people want to hang on to you.
They
associate your belongings with your person.
Right.
So when you don't have an estate plan and your wishes aren't out there, instead of mourning, they use that as a way to cover the mourning, right?
Of course.
So,
but David, many years ago, I had this discussion with a sociologist that was talking about how people should pay for long-term care with their properties, and I reminded her that in minority communities, oftentimes the only thing people can pass on is that adobe hut that you're talking about.
Right.
But it means the beginning of safety and security, not only for them, but for their children.
Right.
So it's important to figure out how to preserve that.
We are going to have to go on our first break. You are listening to AARP Arizona Hispanic Connection. The subject today, Living Trust. How are you going to transfer your wealth? How are you going to transfer your assets? What arrangements are you going to make? Stay with us. We'll be right back.
Welcome to AARP, Arizona Hispanic Connection. Educate. Celebrate. Connect. Arizona Hispanic Connection.
Thank you. Thank you for staying with us. This is AARP Arizona Hispanic Connection. I am so glad and so happy that we have shows like this and that we have experts in the community. They can come in and educate all of us on these important issues. Transferring wealth when we, begin to get up in age, as they say, and there has to be a kind of, I suppose, an age that is recommended. Maybe you recommended that those things can change, right? So you can make them and then change them as you move on. So it is very, very important to know what how we're going to transfer the wealth, whatever it is. It could be an adobe house, or it could be a mansion, or 20 houses, or $1 million, whatever it is. So, and that's my next question to any of you. What are common sources of wealth, assets that people deal with in estate planning, and more specifically, living trust? What are those sources of wealth that are included in those trusts typically?
Oh, well, you can put whatever property you'd like to title into the trust. So most generally houses. You can leave your trust as your beneficiary on many accounts, insurances, bank accounts, pretty much you name it, you can put it into a trust.
Mm-hmm. And Lupe?
Jewelry too.
Mm-hmm.
Sometimes people have pieces that they really value.
Right.
Or the family will value.
Yeah. Allison, anything that we left out? So you have your accounts. What other assets or, accounts, whatever, do typically or are typically included in this type of estate planning?
Alejandro covered the major assets that would be the financial resources, accounts, and homes, and then oftentimes a comprehensive estate plan includes more than just the pieces of the trust. And we were talking about other documents off the air that should also be considered, not just from the financial perspective, but really as a deterrent to avoiding incurring future legal expenses.
Now, just stay with me for just a second, Allison. When it comes to long-term care, is long-term care something that can be included in a trust, and how does that look like?
I think long-term care planning it can often coincide with estate planning, but many times I would consider a primary focus of my firm, and if we need to table this issue for later, elder law and long-term care planning, sometimes happens simultaneously with estate planning, but often is a completely different beast.
I see. Okay. And as appropriate, feel free to mention it. So let's go with the basics, because I know that a lot of people are just going to feel, I guess, fine if they do a will, if they do just a testament. Lupe, what are that basic form? If somebody just wanted to feel some peace of mind, and they don't feel that they're going to the estate planning and the living trust and all that, what are some basic concepts that people can do, and where can they get some help for that level of planning?
Actually, David, I really worry about young families, and I'll tell you why. They have children. They have children that they have to make decisions for. Who's going to care for them? How are they going to be cared for? All those things. So when we are talking about last will, the last will is actually just a document that provides essential details of who will inherit, when and how they will inherit, and who's in charge of doing it. And so for me, when you have minor children, it requires a lot more planning, a lot more thinking about who it is that should be taking care of your children. When do you want them to get, if you have substantial assets, when do you want them to come into them? You know, you're not going to leave a child, not that I know very many people at this level, but let's say you're a multimillionaire. You're not going to leave that to a child with no instructions of how to take care of that, or who's going to handle it for them. And it's really important that you remember that when you have children, you should appoint a guardian for them. So that's a very basic step. But again, from personal experience and remembering how many years, because we were afraid of what it would cost, we just went with, actually at first with one I wrote myself by hand, and just told friends about it and had it notarized, which now I shudder to think,
if you wrote
what
that
if
by
something
hand,
happened?
if you wrote that by hand, what is legally that considered? Is that
Sure.
is that as good as a will or testament?
It's considered a holographic will.
Okay. So
which
it's
is
a
not
will.
which is not recognized in Arizona legally, unless it's in your handwriting. But if it's notarized, then I believe it takes it out of. So it just has to be written sort of out of desperation. I think that's why Arizona recognizes it. Like I'm dying right now, and I'm leaving this to this person.
Right.
That's the theme behind it. Why-
Or in my case, I started a job where I was required to travel quite often, and I started worrying about that. I said,
Right,
oh my God, what if something happens when
Okay,
I'm
so
gone?
what is wrong, or why isn't it adequate? Let me just change my wording. Why isn't it adequate to just have a will or a testament? Either you wrote it down, or you went to the Attorney General's website or office and you got some sort of formal documents and you just did it. What is inadequate about that? Or why is it, what's going to happen? Because the issue of probate, I think, is a big element here. Can you address that?
Yeah, well, what's going to happen is, number one, it may be the adequate way for a person. That's why you should see an attorney to find out what the best mechanism for you. Estate planning is much like a toolbox. There's several tools. You have to find out the tool that works best for you and your family. But usually a will is not the best way. Number one, because it's public and we want our information to be private.
Okay.
And number two, it has to go through
Why
probate.
is it public?
Because it has to be submitted to the court.
Okay, so
for probate.
it's submitted to the court, and then when it's going through the process, everybody can know about it.
Yeah, if they want to.
If they want to,
But
okay.
in addition to that, it has to go through court, which means there's fees that are involved in probate.
So it's private. It's not private. It's public, and fees.
Correct.
So it's really just a document. It's really not. Nothing has really happened, but it's a document that states, "I want this to happen when I die." Correctly?
Right. It's just directing who you want to receive what and how you want them to receive it. The court then gets involved in your financial affairs. If you don't name a guardian for your child, then of course another judge will have to name that. If you have a dog you care for, you won't be able to do that.
So people that are uninformed, do you believe that they think that that's going to do it, and that once the person dies, they're just going to grab whatever the person designated? Do you think there's a misconception of that?
Yeah, I
they don't
think so.
really know that eventually it's going to be a whole process in terms of the probate. because you're going to have to go through probate, right?
Not with the trust.
No, I'm talking about with just the will or a testament.
Right.
So let us just be clear. A will and a testament is an option, but it's very inadequate, would you say?
Yes,
In
it's
many
a
instances.
foundational document, and it can help shore up a more comprehensive estate plan.
Okay.
But one of the topics that we discussed was accounting for guardianship of minor children, and that's a subject that's personal to me. I am in a blended family. I married someone with 2 wonderful children, and then we had 2 wonderful children of our own. I'm kind of laughing because they're young, but it is extremely important to consider as part of a comprehensive estate plan the care for your minor children, who will care for them, especially if you are in a family where there might be various options, and how do you plan for that, and what conditions do you place upon certain family members that might be in a position to care for your children. And you mentioned it, Lupe, when you were where you were starting to travel for work. And so I think this is, you start to think about, what plans have I made, not just financially, but really for the day-to-day care of my children.
So that is a little bit of a different aspect, not necessarily financially, but more assigning a person who would take care of that family member, especially a minor or maybe a person with disabilities, etc.
Right. And it absolutely can have there are financial implications in that you also need to consider where your wealth will be transferred to give people the ability to care for those minor children.
So let us kind of summarize. Even a piece of paper, a note that you write with your signature, if you go to the notary, that could somewhat help some. Then you come to a more formal one where you do a will of testament. That may be even better. But I assume from what I gather in my own, experience and research, so a state plan or estate planning is what I would imagine you advocate for. What you would recommend is to do a holistic planning
Correct.
that will basically cover anything and everything related to assets, assigning people to take care of children, etc. So am I reading this correct?
Right. When we
That
say
is the way to go.
When we say estate plan, it's not only planning for your death, it's planning for your incapacity, incarceration, deportation, going out of the country. So it plans for when you can make decisions for yourself or when you pass away. So it's a series of documents that typically will include a trust, a will, a living will, powers of attorney, both financial and healthcare powers of attorney, and other documents that you may need to affect your wishes when you're not around. And like I said, it could be that you're going out of town, you're traveling a lot, and you need someone to do something for your child and sign on your behalf. A power of attorney will work in that case. You may be in a coma for a month. You may, for some of our brothers and sisters who are not here legally are deported. They have property here. They need someone to take care of it in their absence.
So is a testament or will and a trust, it will still assign somebody, correct, to basically
Yes.
take care of
A trustee.
a trustee. In either case.
No, in a will, it's called a personal, an executive, personal executor or executor.
So there's still a person involved that is being assigned to take care of that. But you're saying that when you do a living trust, that takes a whole different form. Look, Lupe, did you needed to make a
No, I
comment?
just wanted to make sure that people understood. As a do-it-yourself for a tradition, I look everything up and say, oh, I can do this. That's one thing. When I looked it up, I thought, oh my God, no, I don't know enough about the law
Right.
to realize what the consequences of what I'm about to put on paper could have.
Right. And I think I said in the last show when we addressed this matter is that when I travel out of the country, I write a little note and say, if I could not be here to make decisions, I want this person to. And, it's almost like a peace of mind that you want to have, but legally, who knows what that's
It may
worth.
not hold up.
What was that?
It may not hold up,
Right. So
especially
that's why
if
it's
somebody
so critical.
challenges it.
Yeah. Let us go on our second break,
Sure.
and we're gonna dive more deeper into the living trust, the types of living trust, and what does that mean. Stay with us. You are listening to AARP Arizona Hispanic Connection. We'll be right back.
Welcome to AARP, Arizona Hispanic Connection. Educate. Celebrate. Connect. Arizona Hispanic Connection.
Thank you. Thank you for staying with us. This is AARP Arizona Hispanic Connection. We are addressing living trust, the transfer of wealth. So this is the third segment already. So let's kind of dive a little deeper. We're kind of moving slowly, so kind of to paint a picture of basically the importance of this and the legalities of this processes that are, very, very important. So now that we put forth that, yes, a will do something. Yes, a testament is better than nothing, but it's not adequate. So you're advocating for more of a estate planning, more inclusive planning. And in your engagements, again, feel free to mention cost, because cost is something that a lot of times scares people. It scares us, So now I understand that there are two types of trust.
Yeah, generally there's your revocable or your irrevocable trust.
So this is going to be important. Why don't we explain the revocable and irrevocable living trust? What is the difference?
Sure. So a revocable trust is a trust where you can revoke it, frankly. You can manage it. You have you can use the assets during your life. You are the trustee while you are living and have capacity to make decisions. So therefore, you can deposit money. You can sell the house. You can take money in and out of the trust, use it to purchase other things. And once
this is a revocable. That means you can undo it. You can change
exactly.
It. Okay.
You do an irrevocable trust. That's usually for tax purposes, for very wealthy people, or for certain situations. And that is right. You cannot, under very certain exceptions, go into it again. It is gone. You can always what's called decant it, but that's only under very certain situations.
Okay, so again,
but then there's also special needs trusts, pet trusts, Miller
Pets?
trusts. Oh yeah, there's all sorts of
I
things.
didn't know that.
And I think it's important to speak about to the Miller's Trust, because that really affects your eligibility for long-term care.
Yes.
And let's talk about that, because I understand that some protect you, right? So what is the trust that if you were going to apply for benefits, it's protected? Do one of these two trusts protect you if you wanted to qualify for benefits, or none do?
So that is a very fact-specific question. It depends on obviously the situation, who controls the resource, who benefits from the resource. But as was mentioned, one very important estate planning mechanism is a Miller Trust, or also known as an income-only trust. And that is something in terms of long-term care planning and possible eligibility for all techs, where I would collaborate with Alejandro, because there is an estate planning document that needs to be properly drafted to keep people's income from not counting as a resource or income that will count against them for the purposes of financial eligibility.
I see. I got a call a couple weeks ago, maybe 3 weeks ago, and this gentleman had Medicaid and food stamps, and he was in a special needs trust. Mm-hmm. So basically, I have to believe that there were a good amount of money in that special needs trust, but he was still able to qualify, and that for benefits based on income,
right?
Like Medicaid and food stamps and housing.
So I have a cousin who's autistic who'll always need some sort of assistance all his life. He's entitled to certain government benefits, not just food stamps or a monthly check, but also assistance from the government, therapy, things of that nature. So when you have someone like that, you would leave a special needs trust where that person would get income from the trust, but for purposes of IRS and for purposes of qualifying for benefits, it does not count as income.
So in actuality, that person would not qualify because he or she has a lot of money. Let us assume
Right.
that it's $100,000, $200,000.
Right.
But you're saying that a trust protects that
It
amount?
protects it from county's income. For example, let's say my cousin received a $100,000 one-time settlement. Well, obviously, that's not going to sustain him for his life.
Right.
He's probably need to purchase a house and other things like that, hire assistance, which is provided by the government.
Right.
So the trust shields him from having that count as income, and he'll get distributions for certain reasons, and that has to be crafted very carefully by an attorney.
So basically, he'll never have access to all the money that is in the trust.
Depends how the trust is written, but
typically.
right.
Okay.
And that is something that I would highly recommend you consult with an attorney on, just because the rules for Medicaid eligibility are so specific and so precise.
Right.
I would hesitate to have someone try to undertake that document themselves,
Yes.
just because of what's at risk
course.
if you don't do it properly.
Right. Okay. So there are different types of living trust. We've just kind of briefly mentioned the revocable and irrevocable. And typically, unless somebody's wealthy and has a lot of money that they want to try to manage the tax liability, if you will, they can do the irrevocable, but we will not have access to that money, correct?
Under very certain circumstances,
Right.
yes.
Okay. And so that's why, from what I gather, then the recommendation is, if you're not that wealthy, to do a revocable.
Yeah, you'd have to.
Where you would still have access to your money. And you're saying that, okay, so it's a document, right? Help me understand. So the parties involved in a living trust, I have some notes, but if you don't mind, the grantor, the trustee, and the beneficiaries. Can you just elaborate on that?
Sure. The trustor, the grantor, is the person who creates the trust. The trustee is the person who's entitled and responsible for administering the trust.
Not necessarily that person's going to receive the benefits, but he or she has been chosen to be the executive or the overseer.
Executor.
The executive. Okay. And then you have the beneficiary.
The people who receive the benefit of the trust.
Got it. So then.
Now it can all be the same person in the beginning.
Oh, okay.
Right. So you can have a couple who are also the trustees and are each other's beneficiaries should something happen. That's how it will basically begin. And then you would add to it as their relationship. They have children and so on and so forth.
Right.
Especially for couples, you're going to want to have somebody will survive someone. And so you want to have, I think, like in our case, we have one where I will be the total beneficiary when he dies. And say the same way he would be if I die. But in the event of both of our deaths, then that piece of who is next and how comes in.
Okay, so we said earlier that a will or a testament will have to go through probate, which means a court proceeding to basically decide and execute whatever that person's will was. And that's going to be public. So pretty much people will know who's getting what. Am I correct? So doing a living trust, then you don't go through probate, and that becomes private. Is that? Am I getting that correctly?
Yeah, I mean that's a big part of it. Yes, that is correct.
Yeah, and then can you elaborate a little bit about the matter of why is it important to have this living trust, especially if, let's say, that you have a family with different or kids from maybe the husband of previous marriage and so on. How complicated can it get, and what should people be mindful in this kind of circumstances when doing the living trust?
I think that's also very factually specific. I've seen all sorts of things. I've seen gentlemen who've had 8 wives and they have children with each wife, and the children don't get along. The wives don't acknowledge one another. So, it's it can get really hairy. And then now he's married to someone else and they have no children. So she would like to receive everything. So I've seen things like that. It really gets really complicated. Allison mentioned she has a blended family, which is probably more straightforward, but you see a lot of blended families.
Right. And one consideration in estate planning is that you want to make sure that there are certainly do-it-yourself forms. And I mean, certainly if anyone does not think they can afford an attorney, I would encourage them to consult with one. And also, you want to make sure that the estate plan is accomplishing what you want it to do. And sometimes that can be the pitfall with, the do-it-yourself or the online is, particularly in a blended family situation, you might think that you are excluding or including certain stepchildren or children or whatever the case may be. And the fact of the matter is that, if not properly drafted, your estate plan is not going to accomplish what you want it to.
And
do.
I believe we are seeing a lot of marriages that are like a second marriage, and you bring in kids
Sure.
from the first marriage. So that's going to make things complicated if you don't take the route of estate planning and doing it correctly.
And you can also lead to lawsuits and tying things up.
And a lot of the money that you were going to get, you're going to have to spend it on. Now, Allison, we still have about 3 minutes for this segment. Would you tell us what sort of things happen in elder abuse? You have elder law, so I assume that there has to be an element of abuse with the older adults. Can you address that?
Yes. So one of my areas is elder law, and that's not really a field of law that a lot of people are familiar with. It's not rooted in common law like many of the areas of law that we are more familiar with. I'll speak to your question about elder abuse. I do not specifically handle elder abuse, but there are law firms and probably more typically than not, they would tend to be personal injury law firms. And those firms can consult with people that are concerned about if a facility that their loved one has been in has met the minimum standard of care. That's the area where I would you most likely see that with wounds and bed wounds and things of that nature.
And I have to believe that there are cases that are maybe more extreme, or who knows, there may be common when children maybe deceive the parents.
Oh yeah, there's caretakers
into signing perhaps documents.
Accountants, of course, yes. There's professionals out there, accountants. I've seen cases where an accountant has had a client signing a power of attorney over to them. I've seen caretakers try to get them away from their children, turn elderly people against their parents. So there's a lot of mind games that are played against the elderly, which is legally called undue influence. So that is something that we see pretty often in this area. I've seen people that about once or twice a week that have these issues.
And before we go on our last break, cost. Can you address the issue of cost, because this scares people? I mean, what are we talking about when we're talking about estate planning in terms of the
Sure.
cost?
So an estate plan includes all of the documents I told you.
Right.
Previously, generally attorneys either charge hourly or they charge on a flat fee. I typically would charge flat fee for everything unless it's ever extremely complicated. And for a single person, it could range between $1,400 to $2,000. For a couple, it could be between
$1,400 to $2,000.
Yes.
Pretty reasonable.
Pretty reasonable. And then for a couple, maybe $2,000 to $3,500,
Got it.
depending on their assets and the requirements. And Allison can speak to her charging.
Right. One thing we talked about off the air was, and Alejandro alluded to this, is that an estate plan is like an insurance policy. And so we pay premiums on insurance policies that we never utilize all the time. An estate plan is something that you will absolutely utilize because your death, or it's really most often your incapacity, what triggers the estate plan. Wow. And that's one thing that people don't think about. And those events are certain.
Yes. Stay with us. We're going to go on our last break. You're listening to AARP Arizona Hispanic Connection. We'll be right back.
Welcome to AARP Arizona Hispanic Connection. Educate. Celebrate. Connect. Arizona Hispanic Connection.
Thank you. Thank you for staying with us. This is AARP Arizona Hispanic Connection. We are addressing a very, perhaps unpopular subject, but very, very important, and it is living trust, transfer of wealth. This is amazing. Transfer of wealth. It almost, I mean, I got a comment on Facebook that says something like this is getting me depressed. I'm not trying to think about dying.
When I consult with my clients, many times I just consulted with a couple who was 25 years old and 27, and you have to put yourself in a mindset. What happens if your spouse dies?
I
What
like
happens
it.
if
You
your
don't
son
shy
dies?
away from the
Yeah,
fact,
yeah,
right?
no. I mean, you have to consider what's called like a parade of evils. Like, what if the worst things could happen?
Of course.
And, so that's when, I kind of have to wear the hat of a counselor and say, well, this is not, we have to plan for it because this is the way it is. So, but I mean, you do. I mean, and clients will sometimes cry, but and I think that's a big hurdle is getting them to get them in that mindset and then get them out of it and know that now whatever's going to happen is ready to go.
Right.
I had a client recently that had was going through a terminal illness and she was getting operated. She goes, well, I hope I'm not going to die. And I was like, well, you have to have this in place, but we have to, plan for the worst. So,
Yes.
yeah.
Right. And, one way to look at estate planning too is to try to convince people that it's about your life as well.
Right.
The focus is just not on, these things that you've accumulated. But it also speaks to your life and to your accomplishments. And so
Legacy?
yes, your legacy, and trying to kind of, turn the perception that people have that is something that's traditionally something that they don't want to deal with. And, making them think about it in a way that empowers them.
Yeah. Let's talk about two more items. And I know, like, for instance, I have designated my wife to be my beneficiary at my 401k. What would happen? How does the living trust and this kind of designation of beneficiaries, do they contradict each other? What takes precedence over what?
Sure. So a beneficiary designation on a bank account, a 401k, a life insurance, so forth is always going to take precedent over what is in a
Please
will or a
repeat
trust.
that because that's important.
Hey, well, let's see if I can say it the same way. A beneficiary designation on a life insurance, 401k, etc., will always take precedent over what is in a will or a trust. And that is very important for people to understand that when they have a trust and they make these bequests to other people, that they need to update their beneficiary designations to reflect that.
Right. Let me ask another question. So revocable living trust, if I do when I'm the grantor, right?
Correct.
If I would be the grantor, I still have access to everything,
Absolutely.
even if it contradicts what I said.
Sure.
Oh,
you can burn it in the fire if you would like. So, yeah.
Okay, so that's basically okay. So I still have control over my house, my bank account, my everything.
Absolutely.
And can I modify that anytime I want?
Sure, absolutely. Absolutely.
Okay, and
So you're free to make any changes as you want to with your attorney. You're also free. Usually what happens if, for example, if you leave someone your car and you purchase a new car, the law will, if it's properly written, it can apply like an anti-lapse gift, which gives the person the new car. So things of that nature. So it has to be properly written because it takes into account
And
the
I
fact that the
assume-
property may not be in the
I
trust.
assume as an attorney, when you're writing this living trust, you're asking all these kinds of questions,
Absolutely.
right? Have you declared a beneficiary on this benefit, that benefit?
Sure.
Because I understand again, that's
Right. And
that's
then we
important.
also provide my clients with a letter when it's all said and done that reminds them to change all their beneficiary designations. Now we can do that, but that's when it gets more expensive, right? That's when the hourly rate would kick in.
Right. The importance of a trust is funding the trust.
And that was my second question. Let's talk about funding the trust. What is that?
It's essentially changing the title of certain of ownership to title the asset, such as your home, into the name of the trust. So the trust itself is a document.
Oh, wait, the name of the trust, but not the name of the beneficiary?
No, the name of the trust.
Did I get that right?
Correct.
Oh, okay, that makes sense.
For example, you own a home, and right now it's in your name and in your wife's
Right.
name. If you have a living will, that a trust, that will have to be changed legally to the trust.
Later on.
No, at the time it's done. That's what you call funding
And
the
as
trust.
you
Oh, you know, I
accumulate-
see. So because you said will, so it's a living
A
trust.
living trust.
Okay, so when you do a living trust,
Sorry.
funding it means you literally change
The
bank
bank-
accounts,
Everything.
a title of
whatever
of-
you want to be in the trust.
into the name of the trust,
Right.
not the name of the beneficiary. I just want to make
Correct.
that clear.
And you
because
can make the trust the beneficiary.
so you're changing the names of this benefits.
So, for example, your house would be no longer titled to David Parra. It would
Right.
be titled to David Parra as trustee of the David Parra Living Revocable Trust.
So that's called funding the trust.
Correct.
The trust.
And if your trust is not funded upon your death, then the trust doesn't exist.
Are you telling me that in some instances people prefer not to fund the trust?
Oh, I don't think it's that they prefer. I don't think they were obviously ill-advised or got lazy and didn't do it, which is why I always give my clients a letter that says, don't forget to, and I always will provide my clients with a deed also for them to file. Sometimes they don't even file it.
Yeah.
And sometimes what I think is important to remember is that you may decide to put certain properties in the trust and have a living, and have a will for whatever is not there. You might have acquired property later on. And that's why I think Alejandro made such an emphasis of saying the complete package would include the living trust, but it also would include a will.
Right. And let me ask, so you let's say you said that you prefer to charge a flat fee. So when they come back to say modify a living trust, then can one assume that the charge will be less? Because now
much less.
It's a modification.
At that point, it will be hourly. If it takes me 30 minutes, it'll be half of my hourly rate.
Got it. And let's come back a little bit more to elder law, because I believe, obviously, there's a lot of bad stuff happening to elders, abuse. Can you elaborate just a little bit more as to what forms of the abuse more directly? I have a feeling that there's also their own children sometimes. Somebody's own children, they may, again, deceive them, if for lack of a better term, relatives, into signing documents or convincing them or this and the other.
Right. One area of elder law is many different areas that coincide. One area where you can tend to see, some abuses is, again, children, neighbors, anyone that has any access to someone. Sometimes it can be people exceeding the scope of a power of attorney. Sure. So in other words, maybe I've given somebody, some certain authority in a power of attorney to do something in the event of my incapacity or my inability to perform that function. But you can have people exceeding the scope, and so that's an area where you can get into guardianship and conservatorship matters, and sometimes those are uncontested because that there's only one family member that can fulfill that function. But sometimes they're adversarial contested matters because you've got siblings trying to convince the probate court that they should be the guardian or the conservator of mom or dad.
Okay, so the issue of funding the trust, you said that you can modify as the grantor, right?
Correct.
You can modify it anytime you want. So that also would apply to when you fund the trust. In other words, you had changed, say, the title of your home into the name of the trust. You can undo that?
Of course. Well, yeah, let's say, you have a house now. You may want to sell that house and downsize or upsize. And if that's the case, obviously, you need to sell that house and get a new house. So you would need to title the new house into your trust. So you're always going to be changing your property.
And now I understand why a revocable is more recommended. And it applies in most cases because that means you can revoke it.
Right.
You can undo it anytime you want. Whereas an irrevocable may protect you against taxes, if you will, or other things. But you pretty much lost, in most cases, I thought you said, access to those. And now, so a living trust, let's say you are the beneficiary, those assets do not count for anything. In other words, they're not legally yours, right? Even though you are the beneficiary of a trust, if you wanted to apply for benefits, for example, government benefits, those assets do not count.
That's very, again, factually specific, so you will be a special type of trust. But generally, those assets are shielded from most creditors, from most, you've protected, you kind of put like a balloon or a wall around your property that protects it from, in many cases, lawsuits, things of that nature.
And let's emphasize that. We're almost have to go, but please repeat that, because so you're saying that if you don't fund the trust, those assets are still in danger of maybe somebody coming after you, maybe
Of course,
to sue
right,
you or
yes.
to this and the other. That's why funding the trust is so critical then.
Yeah, it's critical because, right, if you don't fund the trust,
They're
you
not
don't-
protected.
Well, they're not protected, and the trust the trust never comes into being. I've had people who they say, well, I have this trust, and I go look up the recorder's office to see to see if the house is titled to the trust, and it's not. So that means that the trust, doesn't exist.
That's a very expensive document
Yes,
that does nothing.
right.
So it's still up to the person, though, doing the trust, whether they want to fund it or not, correct? They can still do a living trust without funding it, correct?
Yeah, I don't see why they would want to, but yeah,
Exactly. You don't recommend it, and
No.
it's not wise to do it.
No, it's
Right.
kind of
Lupe,
ridiculous.
would you mind just give us a concluding words to our community? I mean, I haven't done it, but I've been thinking about it, and it's just a matter of time.
Well,
I'm
shame
going
on
to
you.
have to do it. I know. I know. I'm the first one that benefits from this
And
show.
as I was
always
telling
say.
you during the break, I have a close friend who I called to see if he would like to participate today. And he said, I don't have one. And I said, what?
So he'll be
Because-
preaching something he's not
he'll
even
be-
doing, right?
Well, no, he wouldn't have. He literally said, no, I can't do it because I'm not practicing it.
Right.
But I really would tell everyone that's listening, explore it at the very least. Explore it. It's important, especially for if you have a home, if you have real estate that you want to make sure it's passed on to whom you want to pass it on.
I just wonder if a show on this, I mean, not a show, but if we had meetings in the community that would address these things, I believe that people
I think
would
people
come.
would attend.
Let's look into that. I want to thank all of you. We run out of time. Thank you so very much. And thank you for joining us today. This was AARP Arizona Hispanic Connection. Have a great day.